I'll take that again. IEBC was also required to provide certified copies of the Certificate of Penetration tests conducted on the IEBC election technology system prior to and during the 27 election pursuant to Regulation 10 of the Elections Technology Regulations 2017. These were not provided. Instead, IEBC issued and certified documents and certificates by professionals which did not conform to the regulation. C, IEBC was also required to provide specific GPS location of each KM's kit used during the presidential election for the period between the 5th August 2017 and the 11th August 2017. This was not provided. IEBC instead provided the GPS locations for the polling stations, which was not ordered to be granted. D, documents for allocated and non-allocated KM's kits procured was provided. However, the information on whether the kits were deployed or not was incomprehensive. E, the court ordered access to technical partnership agreements for IEBC election technology system, including a list of technical partners, kind of access they had, and list of APIs for exchange of data with partners. The documents were issued with the exception of the list of APIs. The court-appointed ICT experts said full information on APIs would have enabled determination of what kind of activities may have taken place. The court had also ordered IEBC to provide the petitioners with the login trail of users and equipment into the IEBC servers, the login trails of users and equipment into the KM's database management systems, and the administrative access login into the IEBC public portal between the 5th of August 2017 to date, being the date of the court order, which was the 28th August 2017. These were also not provided. Instead, IEBC provided pre-downloaded logs in a hard disk whose source it refused to disclose. The IT experts agreed with the petitioner's contention that the first respondent should have demonstrated that the logs emanated from the IEBC servers by allowing all parties to have a read-only access. Alternatively, the first respondent could have accessed the information in the presence of the petitioner's agents. Partial live access was also only purportedly provided on the 29th August 2017 at about 3:50 p.m. without ability to access the logs or even view them. The exercise was therefore a complete violation of the court order, and the access was not useful to the parties or to the court. It is clear from the above that IEBC in particular failed to allow access to two critical areas of their servers: its logs, which would have proved or disproved the petitioner's claim of hacking into the system and altering the presidential election results, and its servers with forms 34A and 34B electronically transmitted from polling stations and CTCs. It should never be lost sight of the fact that these are the forms that Section 39(1)(c) of the Elections Act specifically required to be scanned and electronically transmitted to the CTCs and the NTC. In other words, our order of scrutiny was a golden opportunity for the IEBC to place before the courts evidence to debunk the petitioner's said claims. If IEBC had nothing to hide, even before the order was made, it would itself readily have provided access to its ICT logs and servers to disprove the petitioner's claims. But what did IEBC do with it? It contemptuously disobeyed the court order in these very critical areas. So where does this leave us? It is trite law that failure to comply with a lawful demand, leave alone a specific court order, leaves the court with no option but to draw an adverse inference against the party refusing to comply. In this case, IEBC's contumacious disobedience of this court's order of 28 August 2017 in critical areas leaves us with no option but to accept the petitioner's claims that the IEBC's IT system was infiltrated and compromised, and the data therein interfered with, or IEBC's officials themselves interfered with the data or simply refused to accept that it had bungled the whole transmission system and were unable to verify the data. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations or tallying centers. That while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15 million. The petitioners also made claims that some forms 34A supplied to them did not relate to any of the existing gazetted polling stations, tallying centers, that while 15,558,038 people voted for the presidential candidates, 15,098,646 voted for gubernatorial candidates, and 15,008,818 voted for members of parliament, raising the questions as to the validity of the extra votes in the presidential election. No satisfactory answer was given to the latter issue, and we must also hold the first respondent responsible for that unexplained yet important issue. Having therefore shown that the transmission of results was done in a manner inconsistent with the expectations of Section 39(1)(c) of the Elections Act, we must of necessity return to the principles in Articles 81 and 86 of the Constitution, which we have already reproduced. Of importance are the expectations of transparency, accountability, simplicity, security, accuracy, efficiency, and especially verifiability of the electoral process. These terms should be understood to refer to A, an accurate and competent conduct of elections where ballots are properly counted and tabulated to yield correct totals and mathematically precise results. B, an election with a proper and verifiable record made on the prescribed forms executed by the authorized election officials and published in the appropriate media. C, A secure election whose electoral processes and materials used in it are protected from manipulation, interference, loss, and damage. D. An accountable election whose polling station, constituency, and national tallies, together with the ballot papers used in it, are capable of being audited. And E. A transparent election whose polling, counting, and tallying processes, as well as the announcement of results, are open to observation by, and copies of election documents easily accessible to the polling agents, election observers, stakeholders, and the public, and as required by law, a prompt publication of the polling results forms is made on the public portal. Verifiability must have had strong significance in the 8th August election because the presiding officers were required to verify the polling station's results in the presence of polling agents before sending them to the CTC and NTC in using the KIEMS kit. The minor KI decision made it clear that Form 34A, being the primary document, becomes the basis for all subsequent verifications. We have already addressed the import of the refusal to obey a court order, and we further note that the whole exercise of limited access to the first respondents' IT system was meant to confirm and verify both the efficiency of the technology and also verify the authenticity of the transmissions allegedly made to the CTC and to the NTC. Non-compliance and failure, refusal or denial by the IEBC to do as ordered must be held against it. So, what of Article 138(3)(c) of the Constitution? It provides, in a presidential election, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the results, unquote. The critical element here is the duty placed upon the Commission to verify the results before declaring them, to ensure that the results declared are the ones recorded at the polling station, not to vary, not to change or alter the results. The duty to verify in Article 138 is squarely placed on the Independent Electoral and Boundaries Commission, the first respondent herein. This duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It is exercised by the various agents or officers of the first respondent, that is to say, the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. The verification process at all these levels is elaborately provided for in the Elections Act and the regulations thereunder. The simultaneous electronic transmission of results from the polling station to the constituency and the National Tallying Center is not only intended to facilitate this verification process, but also acts as an insurance against potential electoral fraud by eliminating human intervention or intermeddling in the results tallying chain. This, the system does by ensuring that there is no variance between the declared results and the transmitted ones. In the presidential election of the 8th August 2017, however, the picture that emerges is that things did not follow this elaborate but clear constitutional and legislative roadmap. It has been established that at the time the second respondent declared the final results for the election of the president on the 11th August 2017, not all results as tabulated in Forms 34A had been electronically and simultaneously transmitted from the polling stations to the national tallying centers. The second respondent cannot, therefore, be said to have verified the results before declaring them. The said verification could only have been possible if, before declaring the results, the second respondent had checked the aggregated tallies in Forms 34B against the scanned Forms 34A as transmitted in accordance with the provisions of Section 39(1)(c) of the Elections Act. Given the fact that all Forms 34B were generated from the aggregates of Forms 34A, there can be no logical explanation as to why, in tallying the Forms 34B into Form 34C, this primary document, Form 34A, was completely disregarded. Even if one were to argue, which at any rate is not the case here, that the verification was done against the original Forms 34A from all the polling stations, which had been manually ferried to the tallying center, this would still beg the question as to whether the scanned forms were and why, as to where the scanned forms were and why the manually transmitted ones arrived faster than the electronic ones. The failure by the first respondent to verify the results in consultation with the second respondent before the latter declared them, therefore, went against the expectations of Article 138(3)(c) of the Constitution, just as the failure to electronically and simultaneously transmit the results from all the polling stations to the National Tallying Center violated the provisions of Section 39(1)(c) of the Elections Act. These violations of the Constitution and the law call into serious doubt as to whether the said election can be said to have been a free expression of the will of the people as contemplated by Article 38 of our Constitution. It was further urged in court by a number of counsel for the first and second respondent that by disregarding Forms 34A and exclusively relying on Forms 34B, many of whose authenticity would later be called into question, in the tallying process, the said respondents were simply complying with the Court of Appeals decision in Maina Kiai. We have already heard that we find little or nothing in this section, in this decision, that is in the Maina Kiai decision, to suggest that by deciding the way it did, the appellate court restrained or barred the first respondent from verifying the results before declaring them, or that it was relieving the former from the statutory duty of electronically transmitting the results. What the second respondent was barred from doing by the Court of Appeal and by the High Court was to vary, alter, or change the results relayed to the National Tallying Center from the polling stations and constituency tallying centers under the guise of verifying. But be that as it may, how spectacularly reassuring to the Kenyan people would it have been if the second respondent on that night of August 11th, 2017, had commenced the declaration of the results with these words: "Fellow Kenyans, the results I am about to declare are exclusively based on Forms 34B, which I have received from all the 290 constituency tallying centers countrywide. I have not verified these results against those tabulated on Forms 34A from all the 40,883 polling stations countrywide. This may sound strange, but I am simply doing this in compliance with the Court of Appeal's decision in the minor KI case. This decision by the appellate court requires me to treat the results as tabulated by the various returning officers as final, and not to attempt to verify them against the electronically transmitted Forms 34A. You will therefore have to bear with me, as court orders must at all times be obeyed. However, all hope is not lost, since I have availed all the Forms 34A on our public portal. Any candidate, election observer, or member of the public is free to download these forms and compare the results thereon against the ones I am just about to declare. If such an exercise should reveal serious discrepancies, then one can petition the Supreme Court to scrutinize them and even annul them, since the Supreme Court has original and exclusive jurisdiction over such disputes. He failed to do the above, and apart from the duty to verify, the first respondent also has the responsibility to ensure that the system of voting, counting, tallying results is verifiable. This is in conformity with the Article 86 of the Constitution, which requires that, quote, "At every election, the Independent Electoral and Boundaries Commission shall ensure that A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including safekeeping of elections materials," unquote. This provision places upon the first respondent the onerous responsibility of devising and deploying election systems that the voter can understand. The first respondent must further be expected to provide access to crucial information that can enable either a candidate or a voter to cross-check the results declared by it with a view to determining the integrity and the accuracy thereof. In other words, the numbers must just add up. We note in the above regard that even where Parliament found it necessary to make provisions for a complementary system, it would not escape from the dictates of Article 86 of the Constitution, and hence Section 44A of the Elections Act provides, as I read, notwithstanding the provisions of Section 39 and Section 44, the Commission shall put in place a complementary mechanism for the identification of voters and transmission of election results that is simple, accurate, verifiable, secure, accountable, transparent, to ensure that the Commission complies with the provisions of Article 38 of the Constitution, unquote. When called upon to explain why all the Forms 34A had not been scanned, transmitted and published on the online portal in line with Article 34 of the Elections Act, the first respondent through counsel alluded to some form of complementary mechanism. However, the description of such a mechanism did not appear to us to meet the yardsticks of verifiability inbuilt in the Constitution and Section 44A of the Elections Act. In their submissions, counsel for the respondents and the second interested party urged us not to annul the election on the basis of minor inadvertent errors. We entirely agree. We have already categorically acknowledged the fact that no election is perfect. Even the law recognizes this reality, but we find it difficult to categorize these violations of the law as minor inadvertent errors. IEBC behaved as though the provisions of sections 39, 44, and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection? Having therefore carefully considered all the affidavit evidence and submissions of counsel for all the parties, we find and hold that the petitioners herein have discharged the legal burden of proving that the second respondent declared the final results for the election of the president before the first respondent had received all the results from Forms 34A from all the 40,883 polling stations, contrary to the Constitution and to the applicable law. We also find and hold that the second respondent declared the said results solely on the basis of Forms 34B, some of which were of dubious authenticity. We further find that the first respondent, in disregard of the provisions of Section 39(1)(c) of the Elections Act, either failed or neglected to electronically transmit in the prescribed form the tabulated results of an election of the president from many polling stations to the National Tallying Center. At this juncture, we must restate that no evidence has been placed before us to suggest that the process of voter registration, voter identification, manual voting, and vote counting were not conducted in accordance with the law. As a matter of fact, nobody disputes the fact that on 8th of August 2017, Kenyans turned out in large numbers, endured long hours on queues, and peacefully cast their votes. However, the system thereafter went opaquely awry, and whether or not the third respondent received a large number of votes becomes irrelevant, because read together, Sections 39(1)(c) and 83 of the Elections Act say otherwise. In passing only, we must also state that whereas the role of observers and their interim reports were heavily relied upon by the respondents as evidence that the electoral process was free and fair, the evidence before us points to the fact that hardly any of the observers interrogated the process beyond counting and tallying at the polling stations. The interim reports cannot therefore be used to authenticate the transmission and eventual declaration of results. For the above reasons, we find that the 2017 presidential election was not conducted in accordance with the principles laid down in the Constitution and the written law on elections, in that it was inter alia either transparent, neither transparent nor verifiable. On that ground alone, and on the basis of the interpretation we have given to Section 83 of the Elections Act, we have no choice but to nullify it.